Hello friends, my name is Amit Jyoti. I am assistant professor at the O.P. Jindal Global University. Now we shall be discussing part 2 of the historical events that led to the advent of human rights. The first part here would be our discussion on doctrine of natural law and human rights. One of the oldest Western philosophies on the advent of human rights is the natural law theory. The said concept came out of the Christian values. It was originally one rule given by God which humans must obey. Natural laws are those which involve an instinctive human ability to distinguish right from wrong. Then came the transformation of natural law to natural rights, which is of course subjective. Hobbes famously wrote, and I quote, "The right of nature is the liberty each man had to use his own power as he will himself for the preservation of his own nature, that is to say of his own life, and consequently of doing anything which in his own judgment and reason he shall conceive to be the aptest means thereunto." Socrates was amongst the first scholars to promote human rights through the theory of natural rights by promoting the idea that human beings need to free themselves from the influence of emotions to have better control over their lives through reason. As Friedman has rightly said, the history of natural law is a tale of the search of mankind for absolute justice and its failure. Hugo Grotius, Thomas Hobbes, John Locke and Kant were the supporters of the natural rights theory. Natural rights theories were prevalent before the advent of the nation state with its organs and political setup. These theories contributed towards the development of revolutionary concept of equal treatment of all men and women and inspired the democratic struggles forcing politics to protect the rights of citizens. John Locke was the chief exponent behind the development of modern natural rights theory in the age of enlightenment. Locke envisaged a state of nature where the human beings were in a state of equality and freedom, where no one was subjected to the will or authority of another. To overcome the inconveniences of the state of nature, men and women decided to enter into what is called a social contract, whereby they will create a body politic to protect the natural rights of life, liberty and property of all the human beings. Scholarly contributions towards the development of human rights have a role to play. Plato and Aristotle's contributions are important. Plato, who was Socrates' student and Aristotle's mentor, contributed extensively towards the development of the concepts of human rights in its early years. Plato's book, Republic, is premised on the question, which is it always better to be just than unjust? Both Plato and Aristotle visualized state as an institution where virtues could be impressed on the citizens who submit to its authority. According to them, without being a part of the state, man is like a beast, worse than animals. Aristotle predicted the concept of justice that will be practiced by citizens who are free and equal before the state. Plato justified the idea of justice by propounding that there cannot exist justice in a state where laws are passed for the betterment of a few rather than the society as a whole. Both Plato and Aristotle distinguished between that which was naturally just and that which was legally just. Next is Cicero's contribution, who was a Roman author and a proponent of natural law and natural rights theory. He emphasized on the universal basis for justice and rights for every individual. He expressed his views on natural law and its universal nature through three writings, which are on the Republic, on the laws, and on duties. In his work on the Republic, he provides for existence of a common law of nature, which provides a higher standard than the civil law, a law of nature that gives both privileges or rights and responsibilities and duties to the truly wise. In his second work on the law, Cicero speaks about the power of the humans to reason, which help him to distinguish between all that is right and wrong, all honorable and disgraceful things. Next are the writings of Epictetus. He was born as a slave, but went on to become a Greek-speaking Stoic philosopher. He emphasized on the concept of fate, where each individual can live the best possible life through his interpretation of external situations. He stated, "No man is free who is not master of himself." His teachings could be summed up in three words, which are tranquility, fearlessness, and freedom. Religious writings and human rights also have a role to play in evolution. The Hindu Vedas, the Babylonian Code of Hammurabi, the Bible, the Quran, and the Analects of Confucius are five of the oldest written sources which address the question of people's duties, rights, and responsibilities. Even though the words human rights do not appear directly in any of these religious texts, yet religion provides basis for the existence of human rights theory as stemming from a law higher than the law of the state and the law whose source is the supreme being. According to the Old Testament, Adam is the image of God. This gives human beings a high value of worth. Similarly, the Quran provides, and I quote, "Surely we have accorded dignity to the sons of man." The Bhagavad Gita provides, "Who sees his Lord within every creature, deathlessly dwelling amidst the mortal, that man sees truly." Theologically, human beings are the creation of the supreme power and should therefore be considered sacred. The rights that flow from the religious text are divine and inalienable by the mortal authority. According to the Quran, as interpreted by Professor Rifat Hassan, is the Magna Carta of human rights and enshrines the principle of freedom of human beings from the bondage of traditionalism, authoritarianism, which is all religious, political, economic, and any other authority, tribalism, racism, sexism, slavery, or anything else that prohibits or inhibits human beings from being actualizing the Quranic version of human destiny embodied in the classic proclamation. The next institution that contributed to development of human rights is the League of Nations. After World War I, attempts were made to secure peace, settlement, and preserve human rights through establishment of an organization called the League of Nations. Despite resentment on including provisions for the protection of minorities and ensuring equality of nations and just treatment of nationals, two articles dealing with human rights did find their place in the covenant of the League of Nations. One is Article 22, which provided that the countries which were formerly governed by the sovereign states but now have ceased to be so and are inhabited by people who cannot yet stand by themselves, in the current world will be put under the tutelage of advanced nations. These advanced nations will be the mandatories on behalf of the League of Nations and would be responsible for the administration, including ensuring freedom of conscience and religion and prohibition of abuses in these territories. Article 23 enunciated that members of the covenant will attempt to secure and maintain and humane labor conditions, secure just treatment for the native habitants, and commit the supervision of agreements relating to the traffic in women and children with the League. The League of Nations also contributed towards protecting of slaves by creating a committee to study slavery, which further drafted the Slavery Convention of 1926. Another institution which is of relevance here is International Labour Organization, also called ILO. Like the League of Nations, it was also created after the First World War. ILO was established with an objective to pursue a vision based on the premise that universal, lasting peace can be established only if it is based on social justice. It was recognized as the first specialized agency of the United Nations Organization in the year 1946. Since its origin, ILO has adopted over 100 conventions which fix international standards on areas, many of which deal with human rights. After the Second World War, it marked the birth of the United Nations and the Universal Declaration of Human Rights. In the wake of the two destructive world wars, there were revolutionizing developments in the realm of international law of human rights. As the Second World War came to an end, the world felt horrified at the effects that were produced by the wars. And the governments then committed themselves to establish the United Nations Organization. Its objective was to maintain peace, prevent conflict, and reaffirm faith in basic human rights. The most significant post-war development was the creation of the United Nations Organization, famously referred to as the UN, with an objective to promote respect for human rights and fundamental freedoms. In the late 1945, leaders of the world's nations met in San Francisco to form the United Nations. Inspired by the great South African apartheid leader, Field Marshal Smuts, they included in the preamble to the Charter of the United Nations an important reference to human rights, which reads as, and I quote, "We, the people of the United Nations, determined to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women, and of nations large and small." The UN Charter provided for the establishment of a Commission of Human Rights. The UN Charter placed the promotion of human rights equal to the maintenance of international peace and security. Through Articles 55 and 56, signatories to the UN Charter pledged to take joint and separate action in cooperation with the organization for the promotion and universal respect of human rights. In an advisory opinion on the continued presence of South Africa in Namibia, the International Court of Justice has reiterated the importance of these provisions by stating that the members are bound to observe and respect human rights. Apart from a few other references to human rights in the UN Charter, Article 68 was inserted that provided for setting up a commission on human rights by the Economic and Social Council. In 1947, the first commission was set up and assigned the task of drafting an international bill of human rights. The Commission on Human Rights decided that the International Bill of Human Rights would have three parts. First, a declaration. Second, convention or conventions. And last, measures of its implementation. The Commission decided that the declaration should contain both civil and political and also economic and social rights, but at the same time, it should be concise and an inspirational document that serves as a foundation for all human rights. For this reason, the Commission decided to separate the formally legal binding covenants, that is, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights, from the initial declaration. The Commission decided to name the document as the Universal Declaration of Human Rights to emphasize its objectives of laying down standards of rights for all people everywhere, whether male or female, whether black or white, whether communist or capitalist, victor or vanquished, rich or poor, for members of a majority or a minority in the community. After long meetings, revisions and discussions, on December 10, 1948, the General Assembly endorsed the text of the Universal Declaration of Human Rights. In the 21st century, UDHR is regarded as possibly the single most important document for establishing human rights standards universally. It is based on the foundational belief of creating a world where each human being can live in dignity and peace. Now, the Declaration has achieved such a stature in the realm of human rights law that its founders wouldn't have thought or expected. UDHR has become an integral part of the United Nations and is often referred in various resolutions. It has certainly become a part of the customary international law as well, and its importance continues to grow steadily. When in 1968, the UN organized the 20th anniversary of the human rights movement in Tehran, which is located in Iran, the liberation of nations formerly under imperial rule was presented as the most significant achievement of the long march of human rights. Resolutions and declarations. The adoption of resolutions and declarations on various aspects of human rights by international organizations has considerably shaped the development of human rights law. Even though such resolutions and declarations are not binding upon the nations, yet they reflect on the moral consensus amongst the state regarding what is required in the area of human rights. In addition to the adoption of the UDHR, which we just discussed, United Nations General Assembly has adopted numerous other declarations focusing on the protection of specific human rights. To name some of them, Declaration of Rights of Child of the year 1959, United Nations Declaration on the Elimination of All Forms of Racial Discrimination 1963, Declaration on the Elimination of Discrimination Against Women of the year 1967, Declaration on the Protection of All Persons from being subjected to torture and other cruel, inhuman or degrading treatment or punishment of the year 1975, Declaration on the Rights of Disabled Persons of the year 1975, Declaration on the Protection of All Persons from Enforced Disappearance of the year 1992. Therefore, we see that declarations as soft law play an increasingly important role in the development of thematic mandate and clarify the specific content of treaty-based human right guarantees. Now we shall discuss the role of some NGOs in advent of human rights. There are numerous non-governmental organizations that are actively engaged at the international level in the task of promoting human rights. Most of these organizations work closely with the locals facing various human rights violations. Their functions include investigating the complaints, raising the concerns with the national government, and various international organizations which can be governmental and non-governmental. And lastly, policy making. These organizations are often engaged in the task of educating people about their human rights and how the abuse of those rights can be prevented or addressed. Some of these NGOs are Amnesty International, Children's Defense Fund known as CDF, Human Rights Action Center, Human Rights Watch, Human Rights Without Frontiers, also referred to as HRWF, National Association for the Advancement of Colored People, NAACP, another Human Rights Council. To conclude, I would say that the concept of human right to begin with emerged intertwined with the concept of nation state, the basic tenet of which was freedom from oppression. The concept of human rights is now focused more on the right of an individual, his liberties, his freedom, irrespective of the nation he resides in. The foregoing evolution took place in a phased manner. Some of the events that triggered the said evolutions have been discussed. It must be noted, however, that World Wars I and II played a major role in triggering the immediate need for such a change. As understood in the modern world, human rights are inalienable rights that every human being is endowed upon by virtue of his being a human. There is no factual clarity on how did the concept of human rights evolve during the years. Modern day human rights come from Universal Declaration of Human Rights of the year 1948. And this declaration came about as a direct result of the consequences the world had faced with the World War II. The purpose of arriving at UDHR was to avoid passing on the burden of war to future generations. Thank you for listening to this module.